Well, the Supreme Court decided today that it will wade into the thorny issue of discrimination in the workplace. It will hear a trio of cases involving people who say they were fired because of their sexual orientation or gender identity. At issue, whether the 1964 federal civil rights law that prohibits employment discrimination also applies to sexual orientation and gender identity. One of those cases involves a male Michigan funeral home employee who asked for permission to dress as a woman at work. Another involves a gay skydiving instructor who challenged his dismissal. And a third case pertains to a social worker who said he was fired because of his sexual orientation. Joining us now with more is Jim Campbell with Alliance Defending Freedom, or ADF. ADF represents the Michigan funeral home that is defending its refusal to continue to employ a male employee who identified as a woman to dress in women's clothing. And thanks so much for joining us, Jim.
My pleasure. Thanks for having me.
Talk about the dress code, which is very important to the G.R. Harris Funeral Home. Why is it so important?
Well, it's important because the primary goal of Harris Funeral Homes is the grieving families that they serve. And so they put in place these policies to ensure professionalism, to ensure that their employees blend into the background, and to ensure that grieving families can focus on each other and their grief.
So why did the funeral home not allow its employee to dress as a woman? Would it have allowed it if the employee was fully transitioned?
Well, in this situation, they have this policy. It's a sex-specific policy. Men dress a certain way, women dress a certain way, and they put that in place again in order to serve the interests of their customers. So under these circumstances, the owner, Tom Ross, determined that the request of this employee was not in the best interest of the grieving families that they served. But nevertheless, he wanted to do right by this employee, so he offered him a severance package, which the employee refused. And instead, Harris Funeral Homes has been battling the EEOC for the last nearly 6 years because the federal government's been targeting them simply to make a political point.
Why do you think the Supreme Court decided to take this particular case and the other two now?
Well, it's an important question whether unelected officials at the EEOC can unilaterally redefine federal law in order to bring about their political goals. Here, we're dealing with a term that's been in the law for over 50, 60 years. We're dealing with the word sex. And taking the word sex and replacing it with gender identity has widespread consequences in the law. For example, doing that would jeopardize the dignity and privacy rights of women by opening privacy facilities like locker rooms and restrooms and shower facilities to men who identify as women. It would also undermine educational and sports opportunities for girls by opening those opportunities to boys who identify as girls. So there's a number of issues that are raised here, and these are important questions that the people should be able to decide for themselves and not have unelected officials decide it for them.
Really, so much at stake here. What is the timeline of this case at this point in time? When might it be heard? What are you looking forward to?
Yeah, the court will likely hear arguments in the fall, maybe as late as the winter, but probably October, November argument. And then the court will likely decide the case sometime next year in the spring or even in the summer.
Jim Campbell with Alliance Defending Freedom, thank you for your time.
Thank you.